Let's talk about the fine print every home buyer and seller needs to know. Property disclosures.
This is a nightmare, right? And it's exactly why these disclosure laws are so important.
In the old days, the rule was simple. Let the buyer beware. You bought the house, you bought its problems.
But things have changed, big time. Now, the burden is really on the seller to disclose what they know.
This all hinges on what's called a material fact. Basically, it's info that could change your mind. And a latent defect? Well, that's a problem you can't see, like a crack in the foundation behind a wall. A patent defect, on the other hand, is obvious. It's that giant crack you just can't miss. It's not just sellers. Agents can get in trouble for fraud, or for just ignoring obvious red flags. Which brings us to probably the biggest, most expensive myth in all of real estate. Yeah, that's completely false, and believing it can be a really costly mistake. As is just means the seller isn't paying for repairs. It is not a license to hide problems. Okay, let's talk about a specific federal law. The key year you really need to remember is 1978. For any home built before 78, sellers absolutely must follow these strict lead-based paint disclosure rules. But let's be clear about what this law doesn't do. It's about disclosure, not forcing repairs. So what about things that aren't physical? Like a haunting. The law treats these very differently. The reason is, most states legally carve out an exception for these stigmas. They don't have to be disclosed. So what's the guiding principle through all of this? It's simple. When in doubt, disclose it. Okay, so you know the rules now. But the real question is, can you spot the warning signs?